Landlords are being blindsided in the state of California by the new security deposit laws. In this quick guide for the best renters and best landlords, we are going to cover the new changes, and stick around to the end for what happens next when a landlord deducts too much from the security deposit. Hey there, Christian Walsh, real estate agent with Wire Associates. We've been helping landlords and renters understand their rights before things go wrong. As of last year, landlords are limited in the amount of rent that they can collect as a security deposit to 1 month's rent. And it doesn't matter what they call it. It could be pet deposit, key deposit, whatever you want to call it. The limit is 1 month's rent in most cases. There are some landlords who are exempt and can charge 2 months rent. That would be landlords who own 2 rental properties or fewer, and as long as it's a total of 4 units or fewer. Those landlords that are exempt can charge up to 2 months rent for security deposit. Long gone are the 3 months rent for furnished units. And there is no such thing as a non-refundable deposit. You can't have any mandatory fees, like a mandatory cleaning fee. All the deposit must have the option of being refundable. AB 2801 changed things in the state of California related to security deposits yet again this year. Now it is required that a landlord must provide photographic evidence when deducting from the security deposit. For renters moving out after April 1st, 2025, a landlord is going to need to take 1 set of pictures after the renter moves out and another set of pictures after any cleaning or repairs are done. These must be provided with the itemized statement showing what was deducted from the security deposit. For those renters who move in after July 1st of 2025, you'll be required to have those 2 sets of pictures on move out. Additionally, a set of pictures will be required just before move-in for that renter. So there will be a total of 3 sets of pictures. You'll have the move-in pictures, the pictures after the renter's moved out, and the pictures after the repairs or cleaning are done. A landlord has 21 days by law to return the security deposit to a renter after the renter has vacated the premises, i.e. given up possession, i.e. handed over the keys to the landlord. The landlord is able to return the security deposit via first-class mail or in person. If mailing it, it would go to the new address where the renter lives. If the renter doesn't give that address, then the landlord is able to send it to the address of the unit that the renter just moved out of. Oh, and what happens if a landlord doesn't make that 21-day deadline to return the deposit? The landlord isn't able to deduct anything from the security deposit and must give the full amount back. What can a landlord deduct for? Well, it needs to be beyond normal wear and tear. Now, this is somewhat of an ephemeral concept. It's not clearly defined in the law what normal wear and tear is, but the new requirements for photos is going to help establish what the rental looked like when the renter moved in and what it looks like after the renter moves out. If a landlord is going to deduct for a cleaning, it needs to be to return it to the same level of cleanliness that the rental was in when it was given to the renter. A carpet cleaning, that can only be charged to the renter if it's required to return it to the same level of cleanliness as what it was when the renter took possession. When a landlord deducts for repairs or cleaning, they will need to provide an itemized breakdown of those deductions, plus invoices for the work, and they're going to have to include those photographs that we mentioned. Pictures can be mailed, emailed, put on a thumb drive, or a link sent through email to the renter so that they have access to those pictures. In the event that a landlord can't provide the invoice with the deduction within 21 days, a landlord is allowed to make a good faith estimate of what that deduction will be, include that. Once the work is finished, the landlord has 14 days to send the invoice to the renter to provide proof that the work actually happened. So what happens if the landlord does deduct too much from the security deposit? What's the next stop? It will be small claims court in the state of California. The limits for small claims court have been increased to $12,500, which should cover many security deposit disputes. And it's important to remember this is a cheaper, faster process than actually going ahead and filing a civil action. You cannot bring an attorney with you, nor can the landlord have an attorney with them. The renter is going to want to bring 3 copies of documentation, one for the renter, one for the landlord, one for the judge. and click the link below because there's a step-by-step instruction process. One other important thing to note is the judge's decision is final. It cannot be appealed. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. Share your security deposit stories in the comments below and let us know what your questions are. Subscribe to our free weekly email newsletter and you won't miss any other updates like this. And speaking of updates, make sure you check out this next video right here. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we can't wait to help you.